interest survives the sale. How is priority usually determined?
The general rule is first in time, first in right. The first interest created generally has priority. However, the source notes important exceptions. Purchase money mortgages. A mortgage taken out to purchase the property often has a special super priority over other liens that might attach to the buyer before they acquire title. Recording acts. This is a major exception we'll discuss further. Properly recording your interest can give you priority over earlier unrecorded interests. Subordination agreements. A senior lien holder can voluntarily agree in writing to make their interest junior to a later created interest. And mortgage modification. If a senior lender modifies their mortgage in a way that harms junior lien holders, maybe increases the principal, the modification might lose its seniority relative to the junior lien holder.
How are the funds from a foreclosure sale distributed?
The source gives the standard order of distribution from the sale proceeds. 1. Costs of the foreclosure sale itself, court costs, attorney fees, advertising. 2. The amount owed on the mortgage being foreclosed. 3. Any remaining funds are used to pay off junior liens and mortgages in the order of their priority. 4. Any surplus left after all liens are paid goes back to the original borrower mortgager.
What if the sale doesn't bring enough money to pay off the foreclosed mortgage?
That results in a deficiency. In most states, the lender whose mortgage was foreclosed can then seek a deficiency judgment. That's a personal lawsuit against the borrower or anyone who assumed the mortgage for the remaining unpaid balance of the debt not covered by the sale proceeds.
Ouch.
Yeah. The source mentions that some states have anti-deficiency statutes, which might prohibit a deficiency judgment after a non-judicial power of sale, foreclosure, or if the mortgage was a purchase money mortgage for a home. Some states also limit the deficiency amount to the difference between the debt and the property's fair market value, not just the sale price, to prevent lenders from seeking large deficiencies after sales that might not have reflected the property's true worth.
Mortgages are complex legal tools that create powerful rights in the property itself. Understanding how they transfer, how priority works, and what happens in foreclosure is crucial for anyone who takes out a home loan.
It moves beyond just a personal promise to pay. It's about the specific real property that stands as collateral.
All right, we've covered ownership, renting, buying, and financing. Now let's bring it all together and talk about proving who actually owns the property and how the system resolves conflicting claims. This involves titles, deeds, and recording acts.
A title refers to the legal evidence of ownership rights in property. A good title analysis often involves examining the chain of title, the history of ownership adverse possession claims, and how recording statutes affect priority.
Let's start with adverse possession. This is the idea of gaining ownership by simply occupying the land for a long time. Squatters' rights.
That's the common term, yeah. It's a method sanctioned by law where continuous, open, hostile, and exclusive possession of property for a statutory period can ripen into legal title, even against the true owner. The source gives us the 4 key elements, often remembered as ECHO. Yes. E-exclusive. The possessor must occupy the land to the exclusion of the true owner and the general public. Co-owners can adversely possess against each other if there's an ouster. C. Continuous. The possession must be uninterrupted for the entire statutory period specified by state law could begin 15-20 years. The use must be consistent with how a true owner would use similar property. Seasonal use can be continuous as appropriate for that type of land.
Okay.
Hostile. The possession must be without the true owner's permission. The possessor is claiming the land as their own, adverse to the true owner's rights. Most states use an objective test. Did the possessor act like an owner? O, open and notorious and actual. The possession must be actual, physically occupying or using the land in a way an owner would, and open and notorious, meaning visible and obvious enough that a reasonable inspection by the true owner would reveal the possession and the claim being made. You can't adversely possess land secretly.
So, the true owner gets a chance to discover the adverse possessor and take action before losing their land. Does the statutory period have to be met by one person?
Not necessarily. Adverse possessors can often tack their period of possession onto the possession time of a prior adverse possessor if they're in privity. The source defines privity here as a transfer of the possessory interest by non-hostile means, such as by deed, will, or inheritance. If A possesses for 7 years and sells their interest to B, who possesses for 3 years, B can tack A's time for a total of 10 years, if that's the statutory period.
Right.
Also, the statutory period is generally paused or doesn't begin running against a true owner who has a legal disability like being a minor, mentally incapacitated, or imprisoned at the time the adverse possession began.
The source mentions constructive adverse possession when someone enters under color of title.
Yes. Color of title means the possessor has a document, like a deed, that appears to grant title but is actually invalid. If they enter property under color of title and take actual possession of part of the land described in the invalid document, they may be deemed to be in constructive possession of the entire parcel described in the document, as long as the true owner isn't possessing the rest.
How is adverse possession, getting title, different from a prescriptive easement, getting a right to use?
The source makes a key distinction. A prescriptive easement grants the right to use another's land for a specific purpose, not ownership of the land itself. While it uses elements similar to adverse possession, continuous, open, hostile use for the statutory period, it crucially does not require the use to be exclusive. Using a neighbor's driveway openly without permission for years might create a prescriptive easement to continue using the driveway, but doesn't give you ownership of it.
Okay, adverse possession. Echo leads to title, requires exclusivity. Prescriptive easement. Similar elements, but no exclusivity, leads to right of use. Clear.
Right. The primary method of transferring ownership today is by deed. The source lists the requirements for a valid deed.
It must be in writing, signed by the grantor, identify the grantor and grantee, describe the land with reasonable certainty, and include words of transfer like grant or convey.
Correct. An invalid deed might be oral, with few exceptions, not signed by the grantor, have ambiguous parties or property description, or use language suggesting a temporary right rather than ownership transfer. But a deed isn't effective just because it's written and signed. It also requires delivery and acceptance.
Delivery means handing over the document, right?
Not just physical transfer. Delivery is primarily about the grantor's intent to make a present transfer of the property interest to the grantee. Physical delivery of the deed creates a presumption of this intent. The grantor keeping the deed creates a presumption against intent. But these are just presumptions and can be overcome by evidence of the grantor's actual intent. The source discusses delivery to a third-party escrow agent. The question is whether the grantor intended to relinquish control over the deed in a way that it would become effective immediately or upon a certain condition outside their control.
Okay.
Acceptance by the grantee is also required, but it's generally presumed if the conveyance is beneficial to the grantee, which is almost always the case for a grant of property.
So, valid deed requires writing, signed by grantor, identified parties' land, words of transfer, plus grantor's intent to deliver and grantee's acceptance. This brings us to the potential chaos if people don't publicly document transfers.
Exactly. That's where recording acts come in. At common law, it was simple. First person to get a valid deed got the property. But this was risky because you never knew if the seller had already sold the property to someone else. Recording acts were enacted to provide a public system for documenting interest in land and resolving disputes between competing claims, usually giving priority to those who properly record their interest.
All states have them, but they aren't identical. The source identifies three main types.
They differ based on whose interest is protected and what conditions must be met. First, the race statute. Priority goes to the party who is the first to record their interest in the land records, regardless of whether they knew about an earlier unrecorded interest. Look for language like first to record or first duly recorded. In a race state, if A doesn't record their deed and B later buys the same property from the same seller and records before A does, B wins, even if B knew about A's prior deed.
Pure race to the courthouse.
Pretty much. Second, the notice statute. A later buyer of an interest prevails over an earlier unrecorded interest if the later buyer took the interest in good faith without notice of the earlier interest. The later buyer does not have to record to win against a prior unrecorded interest. They only need to prove they were a bona fide purchaser, bought for value, and without notice when they acquired the interest. Look for language like in good faith or without notice. If A doesn't record and B buys later without notice of A's deed, B wins, even if B never records.
Okay, notice is key there.
Third, the race notice statute. This combines elements of both. A later buyer prevails over an earlier unrecorded interest if the later buyer took the interest in good faith. Without notice, A and D is the first to record. Both conditions must be met. Look for language like in good faith, without notice, and first to record. If A doesn't record and B buys later without notice, B only wins against A if B records before A records.
So whether notice matters and whether recording first matters depends on the specific state statute. What counts as notice?
The source defines three types. Actual notice, you have direct personal knowledge of the prior interest. Someone told you, you saw the unrecorded deed. Inquiry's inquiry. Notice you don't have direct knowledge. but you are aware of facts that would cause a reasonable person to make further inquiries, and those inquiries would have revealed the prior interest. Common triggers include someone other than the seller being in possession of the property or using it, or a reference in a document in the chain of title to another interest. And record notice, or constructive notice. You are legally deemed to have notice of any interest that is properly recorded in the chain of title for the property. The recording system is public, and buyers are expected to search it.
Recording your deed provides record notice, which is crucial protection in notice and race notice states. The source also notes that only purchasers for value, those who pay consideration, are protected by recording acts. Someone who receives property as a gift, a done, generally is not protected against prior unrecorded interests.
That's correct. However, the shelter rule protects a grantee, even a done, who receives property from a grantor who is protected by the Recording Act. The grantee is sheltered by the grantor's status and receives the same priority the grantor had.
What about the doctrine of estoppel by deed?
This applies when a grantor delivers a deed purporting to convey property that they do not currently own. If that grantor later acquires valid title to that same property, the doctrine prevents the grantor from denying the validity of the original deed. The title the grantor acquires automatically passes to the original grantee by operation of law. The grantor is estopped from claiming they didn't own it when they purported to convey it.
Recording acts and these related doctrines are clearly the system's way of bringing order to property ownership, providing a public record and rules for resolving conflicting claims.
They are fundamental for ensuring secure and marketable title.
When property is transferred by deed, the deed itself often contains promises from the seller about the quality of the title. The source describes different types of deeds based on these promises, known as covenants of title.
Yes. The type of deed determines the level of legal protection the buyer receives from the seller regarding title defects.
What are the main types?
The source details 3 primary types. First, the general warranty deed. This offers the buyer the most comprehensive protection. The grantor makes 6 specific covenants of title and warrants against defects that arose at any time in the property's history, including periods before the grantor owned it.
Okay, the gold standard.
Kind of, yeah. Second, the special warranty deed. The grantor makes the same 6 covenants, but the warranty is limited. They only promise to defend against defects that arose during the time the grantor owned the property. They make no promises about the title's condition before they acquired it.
Less protection.
Definitely. And third, the quitclaim deed. This divides the buyer with the least protection. The grantor makes no covenants of title whatsoever. They simply transfer whatever interest they might have in the property, if any, without any promises regarding the title's quality. The buyer has no recourse against the grantor if the title is defective.
So for a buyer, a quitclaim deed is the riskiest because you get 0 promises from the seller about the title. A general warranty deed is the safest.
Exactly. The choice of deed type shifts the risk between the buyer and seller regarding potential title issues.
You mentioned 6 covenants of title. The source divides them into present covenants and future covenants. Why is that distinction important?
The distinction determines when the covenant is breached and who has the right to sue for the breach. Present covenants. These are promises about the state of the title at the very moment the deed is delivered. If the title is defective at that instant, the covenant is breached immediately. These covenants do not run with the land, meaning only the immediate grantee, the person who received the deed directly from the grantor making the promise, can sue for a breach.
Okay, only the first buyer.
Right. The 3 present covenants are: covenant of citizen grantor, promises they own the estate or interest they are conveying. Covenant of right to convey grantor, promises they have the legal power or authority to transfer the interest. And covenant against encumbrances, grantor promises there are no undisclosed encumbrances on the property interest conveyed, like liens, mortgages, easements, etc.
Got it. What about future covenants?
Future covenants. These are promises about what the grantor will do in the future. They are not breached at the moment of conveyance, but only later, when the grantee or subsequent owner is actually disturbed in their possession or title by a third party, asserting a superior lawful claim that existed at the time of the conveyance. These covenants do run with the land, meaning that subsequent grantees, people who buy the property from the original grantee, can sue the original grantor for a breach.
Ah, so later owners can benefit.
Yes. The 3 future covenants are: covenant of warranty grantor, promises to defend the grantee's title against lawful claims and compensate the grantee for any loss if the title proves to be inferior. Covenant of quiet enjoyment grantor promises the grantee's possession and enjoyment will not be disturbed by a third party with a superior lawful claim existing at the time of the conveyance. It's essentially the same protection as warranty. And covenant of further assurances grantor promises to perform any reasonable acts necessary in the future to perfect the title they have conveyed to the grantee.
So present covenants are a snapshot of title now, sued by the first buyer. Future covenants are a promise of protection later if a problem arises, sued by any subsequent buyer who is disturbed. And the type of deed tells you which of these promises the seller is making and how far back in time those promises extend.
Exactly. It's a critical part of what the buyer receives when they get a deed.
Okay, the source just briefly touches on a few other areas. Other ways property interests can be transferred or restricted.
Briefly, yes. Property can pass at death by will through specific gifts or the residuary clause. But gifts can fail by ademption. The testator doesn't own it anymore when they die, or lapse the beneficiary dies first, unless an anti-lapse statute saves it. Property can also be held in trust, managed by a trustee for beneficiaries. And if there's no will, it passes by intestate succession based on state law, usually to close relatives.
What about restrictions on selling property, restraints on alienation?
Right. Direct restraints on transferring property are generally void because the law favors free transferability. A total ban, a disabling restraint, is always void. Restraints based on race or other protected characteristics are never enforceable. Other types, like forfeiture restraints, you lose it if you try to sell, or promissory restraints, you promise not to sell, might be valid if they are reasonable in purpose, scope, and duration, especially on life estates or future interests. But restraints on the use of property are generally okay.
The source also flags easements, covenants running with the land, equitable servitudes, and zoning as other ways land use is regulated or shared.
Yes, these are huge areas themselves. Easements are rights to use someone else's land. Covenants and servitudes are promises about land use that can bind future owners. Zoning is governmental regulation.
And fixtures, personal property that gets attached.
Correct. When personal property is attached to real property so permanently that it becomes part of the land, like a built-in bookcase, it becomes a fixture and passes with the sale of the real estate unless the contract says otherwise.
Finally, water rights, support rights from neighbors, and air rights.
Yeah, just acknowledging that ownership isn't just the flat surface. It includes rights related to adjacent water, the right to have your land supported by your neighbor's land, and rights to the airspace above, though those are limited.
We've covered a vast amount of ground in this deep dive, from the most basic forms of ownership of future interests to the complexities of contracts, mortgages, and landlord-tenant relationships. We've seen how recording acts protect interests and how title passes through deeds and covenants.
It really highlights how interconnected all these concepts are. Buying, selling, renting, inheriting, they all rely on this fundamental legal framework. Understanding marketable title, your rights as a tenant or landlord, what a mortgage really means as a security interest, or the implications of different types of ownership, it empowers you in these crucial life decisions.
Exactly. These rules aren't just theoretical, they shape real-world interactions, disputes, and wealth transfer across generations. Knowing whether you have a fee simple, what rights a life tenant has, or the difference between an assignment and a sublease can save you significant headaches and expense.
It makes you think about the history embedded in every piece of land. The past owners, the old deeds, the easements granted decades ago, the covenants from a subdivision's creation. It's all part of the story of that property.
What's fascinating here is how these ancient concepts like estates and future interests continue to govern modern transactions, adapted and refined over time, but still rooted in the idea of dividing and defining rights in land across time and among different people.
So here's a final thought for you to mull over. Given the complexity and the potential for unexpected issues like unrecorded interests or defects in title, how much due diligence do you think a buyer really needs to do? And at what point does relying solely on legal documents and recording become insufficient compared to physically inspecting the property and its surroundings? How much does the legal description on paper match the reality on the ground?
A crucial question for anyone involved in a property transaction. That's all for this deep dive into real property. We hope this breakdown helps you navigate the legal landscape of land with a little more confidence.